Good morning and welcome everyone to the Illinois Recreational Marijuana Law Impact on the Workplace webinar. I'm Christina Anderson, Corkville Safety Team Manager, and I will be monitoring the webinar this morning. The webinar is sponsored by Corkville Insurance Agency. Judging from the number of persons registered for this webinar, we know that the Cannabis Regulation and Tax Act has many Illinois employers concerned about the impact of this new law might have on their businesses. We are privileged to have Jeff Risch and Matthew Horn from Smith Amundsen with us today, sharing important information on what employers need to prepare before the CRTA takes effect on January 1st. The webinar will be approximately 1 hour, followed by a Q&A. Feel free to type your questions in the chat box as we move through the webinar, and we will do our best to answer as many questions as possible during the Q&A. I'd also like to remind everyone attending to mute your phones if you haven't already done so. And now I'd like to begin the webinar by introducing our speakers. Jeff Risch literally wrote the book on labor law employment law for Illinois employers through the Illinois Chamber of Commerce. As chair of the firm's expansive management side labor employment practice group, he oversees a team providing comprehensive counsel to employers across the country. Jeff is often asked to speak on trending topics in labor and employment arena by clients and educational providers around the country. Matthew Horn is co-chair of the firm's construction practice group. Matthew oversees a team providing comprehensive litigation and transactional services to his clients in the construction industry. As chair of the firm's OSHA practice group, he oversees a team ensuring that clients in all industries are in compliance with applicable safety and health regulations. When compliance issues arise, he represents clients at all stages, from the initial initiation of an OSHA inspection through the litigation of any citations issued. So let's get started. Jeff, I'll turn it over to you.
Thank you, Christina, and thank you for allowing us to take part in this very important topic and something that is gaining more and more interest and more confusion day by day. And thanks to Corkville Insurance for putting on this timely and very important subject matter webinar. The long and hard truth of what's going on in Illinois is that no one really knows where this is all going to lead. No one knows how judges, labor arbitrators, administrative officials, and investigators will decide cases, disputes, controversies claiming wrongful termination or refusal to hire under Illinois law. Particularly this law, and the medicinal part is the medicinal part, the recreational part is the recreational part, two separate laws dealing with and legalizing the use of cannabis, the possession of cannabis. The medicinal part has been around for a number of years here, and we're going to dissect that a little bit here this morning. The recreational, of course, is very new, and we're going to be dissecting that as well. But what I think is important to note for purposes of today and the discussion that we're going to get into today is the statutory framework is not as clean, clear, and crisp as I would want it to be, as you would want it to be. So when we're working through these concepts and the statutory language, we need to keep in mind that you as a business, as an operation, you need to pick your lane. You need to determine what is right for your business and operation. And as the law perhaps becomes more clear, good or bad, depending on your perspective, in the coming legislative sessions or through case law, we're going to have to literally put our best foot forward and dive into this as responsibly as we can. Now, courts outside of Illinois, I can tell you, in areas of Oregon, Colorado, California, Washington, where recreational weed has been around for a number of years, they have historically been fairly pro-employer. Not so in recent years. In more recent years, and dare I say 2017, 2018, 2019, particularly in the Northeast, we're seeing more and more pro-employee cases. And now those pro-employee cases are tied closely to medicinal use of marijuana, where courts have come down negatively on employers who haven't done the right thing, the right approach for medicinal use of marijuana, not recreational. But I think it is telling of where this is shaping and where we're going just on a national level, and how that may play into Illinois courts and some decision making going forward. So as we go through this presentation, and you all are so unique, there's not one of you that should be looking at one another and saying, I'm going to do what my business partner down the road is doing. I'm going to be doing what another company that I know is doing, because if they're doing it a certain way and I do it the similar way, then I can't get into trouble, and this is all going to be nice and neat and clean. I think that's a huge mistake, folks. You have to evaluate your own risk tolerances. You have to evaluate those risks unique to not only your industry, but to your operation. What are you willing to tolerate? What are you willing not to tolerate? What are your sensitive areas? Because you have, as Matt can attest, as the OSHA guru, you have an obligation to maintain and provide a safe work environment. You owe that to your workers, and just general liability 101, you owe it to the public, your customers, your suppliers, your vendors. You owe it to the public at large. So evaluating your risks, I think, takes into consideration you have to go through the exercise of evaluating your safety sensitive positions. As we go through this, I think that the policies, your standards, your approach is going to be dictated by safety sensitive or other key positions. Might not be safety sensitive, might be a key financial position such as a CFO, and implementing policy and practices that are really unique to your workforce and groups of workers, depending on the nature of their job and their specific job duties. In other words, not only are you going to have a policy, a drug testing policy, and a drug-free awareness policy unique to your business and operations, but you're going to have a drug-free workplace and a drug testing policy specific, the drug testing component that's going to be unique to positions or groups of positions, particularly those that are in key financial positions versus those that are in key safety sensitive positions versus those that are not in either of those two categories. So the problem we have is we've got a lot of people wanting to make money on this, and now's the time. I don't know, they just woke up one day and decided, let's start pushing this. Let's start pushing the lobbying, the advocacy. There's a lot of money behind this, not only the politics behind it, but the money behind the politics. And now Wall Street is behind the movement of recreational marijuana. And when Wall Street gets behind something, it's here to stay, folks. There's a lot of money to be made. Unfortunately, with that eagerness to be, fear of missing out and being the first one to to be on the ground floor, so to speak, the science is not up yet with the law and the legality behind this drug. Unlike other tests for alcohol and field sobriety examinations and whatnot, use of marijuana does not necessarily automatically equate to impairment. You've heard that before. I mean, there's not this use of marijuana. Does it equate to impairment automatically without any doubt? And that's just, the science just isn't there yet. And because marijuana is a Schedule I drug, it's a Schedule I, and it's, for right now, it looks like it's going to be remain as a Schedule I. We don't have the science and the research and development behind this, particularly on a federal level. So this is really putting, local law enforcement. This is what I'm hearing, and I'm not in law enforcement, and I'm not a medical doctor, and I'm not a scientist. I'm just a labor lawyer. But what I've heard and the information that I've been able to ascertain over the years, and particularly in recent months and weeks and even days, is that really the breakthrough in some of this testing to make it more reliable and more accurate is really coming on a state level and being developed on a state level. And different states doing different things and not having this national push is a detriment. It's a detriment to everyone. So a confirmed positive drug test, that's the pun intended. Isn't that the burning question? If I've got a confirmed positive drug test, that means I've got a medical review officer where proper chain of custody and collection and lab procedures have been followed. Can I take adverse action against somebody who tests positive, confirmed through a medical review officer, proper chain of custody, proper collection and lab procedures been followed? Doesn't that make me bulletproof here? And of course, the answer is no. Nothing makes you bulletproof in this world, but it's a one heck of a good defense if the employer were to take adverse action against somebody, of course, presuming that has been communicated to the worker in advance through properly established and published policies. Your position as an employer starts and maybe even ends with, what does your policy read? How consistent are you in implementing that policy and maintaining that policy, and doing so in a non-discriminatory, non-retaliatory way? That's huge. That is huge in this analysis. So I believe that a confirmed positive drug test goes a long way of providing a defense. Of course, if I have, and this is going to segue into our analysis of the Illinois law here in a moment, but if we have documented quote unquote symptoms by trained management supervisory personnel that can document and freeze good facts that tend to suggest that somebody may be impaired, poor performance, attendance, or just the standard behavior and conduct associated with use of marijuana through trained personnel. If I have that together with a confirmed positive drug test, I'm feeling really good. I'm feeling really good as a defense lawyer defending any sort of legal challenge that may come up. So, this is recreational marijuana. It's legal in 11 states plus DC. Last I checked, it's decriminalized in 14 states. And of course, this excludes local ordinances and a local practice of just decriminalizing it altogether for marijuana use and possession. I remember, and the reason why I have this slide up here is Illinois was the first state to pass actual legislation through the state legislature. The states that have legalized marijuana before Illinois did so primarily through voter referendum. A plurality of voters coming together saying we want to decriminalize and in fact not only decriminalize but legalize the use of recreational marijuana. Illinois was the first one to codify it. In Illinois law, the 610 pages. I don't know if you've read it. I don't reckon. Well, you can read it. That's 610 pages. It's thick. There's like 6 pages dedicated to employment. It was almost like an afterthought at the 11th hour, in my humble opinion. But I'll get more into that momentarily. Before I get to the Illinois law, remember this recreational stuff. This is not what Cheech and Chong smoked. If you don't know who Cheech and Chong is, I don't know, you have issues. But the Cheech and Chong brand of marijuana back in the 70s, 80s, the potency level is just different than what the potency is now. The street level THC today is around 13%, and some potencies are, there's Colorado. What's going on in Colorado right now? They're sort of on the, they're really into this stuff. Their potency on the street, I heard, is 30%. I mean, that's pretty extreme compared to the 1% being smoked at Woodstock, and even when I was in college, the potency at THC in the early 90s was around 3 or 4%. The concentrates, and you get the concentrate, that potency can be upwards of 90%. So I am told. It's just it is a different drug. It is a different drug than what it was yesterday. And that potency, what do you think is going to happen with that potency, folks? Right? You think we're just going to let it be? I mean, with capitalism, being injected, with Wall Street money being injected behind this, with venture capital money being backed into these advances in the dispensaries and the manufacturing, the potency is just going to go up. It's going to go up. It's going to go up because, again, it's competition, and what can we do to get that high more quick and long lasting? Now, hemp is different. Hemp is it's a variety of cannabis, but it has less than 0.3% of THC in it. So there's little to no psychoactive component. You'd have to rub, eat, smoke a heck of a lot of hemp to get any sort of high from it, and of course to test positive through a drug testing. That is, that's an excuse that really is fairly lame when that is used as an excuse if somebody does test positive for marijuana today. It was just hemp. It's CBD, or it's legal. It's lawful, right? So yeah, I don't know why I'm positive for marijuana, but it's just hemp. It's not an excuse. It's a lame excuse, and it shouldn't exonerate an employee who is testing positive for cannabis confirmed by your medical review officer, a third party. And it's not just being smoked. I mean, these candy bars. I mean, it looks like they look like the Mars bars and the M&M bars out there, the Hershey bars that are being manufactured. It looks very similar. They're very good in their advertising, and the consumption through food, through oils, through lotions. It's just not being smoked. Of course, what I hear is that the smoking, you smoke it, it's just a faster consumption of the THC. It's going to get into your body faster. You're going to get a more immediate high from smoking it versus ingesting it and having it go through your entire body before it gets through into your livers, and it needs to be absorbed through your blood. It takes longer if you're consuming it by eating it or by rubbing it through some sort of lotion or oil. And so the effects, depending on whether you're smoking it or eating it, it's going to be a little different depending on how that is being consumed. Now, before I get to the Illinois law, that 30-day urine, we hear about that a lot, is, how that's the use versus impairment. If I'm using this, a chronic user, then this drug is going to be detected in your urine for 30 days or 30 days plus, depending on how much you're consuming. That could last in your urine for well in excess of 30 days. I've heard 45 days. I've heard 60 days, depending on how much you're consuming on a day-to-day basis. This is why this urine issue and the spike, when you smoke it on day one and you stop smoking it, it could still be in your system 30 days plus after you last consumed it.
Hey, Daniel, who gets bill-o-lading? Because I don't get bill-o-lading.
Yeah, if you
I'd
guys
like
can
to
mute your
remind
phone.
people to mute their phone. Sorry, Jeff.
That they're here. They are.
Excuse me, please mute your phone.
Yeah,
Thank you.
Everybody can mute their phone because we could hear you. There's a great question. Calvin, you got a great question out there. Is there a level for marijuana like alcohol, or is it just a positive test? You're either pregnant or you're not. You're either you got it in your system or you're not. Calvin, I'm going to force you to wait, because I'm going to answer that question. I'm going to give you everything you can know at this point on the threshold of impairment and the level of marijuana in the system that you're going to be able to treat and manage as an employer. So it's going back to the urine level. The reason this slide, the elimination from the system slide, this is why I am advocating for my clients and contacts to rely on saliva, going to the saliva testing. In fact, the breakthroughs that I'm hearing and reading, mostly through the good work of law enforcement, is gravitating to saliva-based testing. And because, you can get this through blood. I don't like needles, and I don't recommend needles being used. It's pretty invasive. And urine, the stuff's just in the system for a really long time after last consumption, in theory, right? And I want to eliminate, it's my job as a defense lawyer to eliminate or diminish the asinine excuses that employees and their lawyers will come up with in the face of challenging an employer's adverse decision. So I want to try and eliminate as many defenses and excuses and reasons to contest our decision-making as employers. And for me, I would like to be able to rely on a saliva test confirming a presence of THC in the system versus the urine specimen. All right, so that is my long-winded introduction to cannabis law in Illinois and through House Bill 1438. Now, I've heard, I heard from the House Bill sponsor on this. I am absolutely convinced that the legislatures and the experts and the defense lawyers and the plaintiffs' lawyers and the judges and the medical experts have no real clear idea what this all is going to result in and what all this means, the statutory framework for employers. Until we get the courts weighing in, this is a best guess approach. That said, despite what you hear, despite what you maybe have been told, or what you, my best guess is that this seems, the state of Illinois seems to be gravitating to regulating and treating cannabis very similar to how we've been treating and regulating and managing alcohol use and abuse in the workplace for years. That's an oversimplification of a very complicated statute for employers. Now, Illinois cannabis law, there's legal limits similar to alcohol of what you can consume, what you can, alcohol you can basically purchase as much as you want. But there's purchasing restraints that go with this. There's the the legality of those that are under 21 and being prohibited, similar to alcohol. But what I want to focus on, there's three buckets that I want to focus on for this statute with regard to employers. The first bucket is Section 10-50 of the law. Section 10-50. If you go to the law, you go to the General Assembly's website, you look at this law, go to Section 1050. There's also Section 10-35. So you've got Section 1050, you've got Section 10-35. And then there's a third bucket, and that's the Illinois right to privacy in the workplace law. And that's a third bucket. This law created Section 10-50, created Section 10-35, of course, but it amended the Illinois right to privacy in the Workplace Act. And I want to go through each of these buckets. And when we go through each of these buckets, this is going to start making a lot more sense and get less foggy for you, I hope. So Section 10-50, this is what employers are allowed to do under the statutory framework. If you're allowed to implement and enforce your drug testing policy. You can have zero tolerance in the workplace, and zero tolerance is not defined in the statute. I'm going to try and give you a little bit of insight into what I think that means, because I don't know if it means what you think it means. It's like that Princess and the Bride movie. Inconceivable. I'm not sure you think that word means what you think it means. Zero tolerance. I'm not convinced, folks, that phrase means what a lot of employers think it means. I can tell you this: it's not do whatever the hell you want. Number two, it allows employers to just flat out prohibit employees from using, possessing, or being impaired while in the workplace, performing their job, or while on call. Now, in the workplace is defined in the statute. We're going to define it here. Performing the job is self-explanatory. Anytime you're actually performing the job. And then on call. On call is defined. Now, going back to in the workplace, it's defined under the Act. And there's a slide dedicated to this, but I'll just save you that time here and define it now. In the workplace is defined in the statute to include any and all places where an employee is performing their job, any and all places of the employer, whether the employer controls it, leases it, owns it. So any property, any parking lot owned or controlled by the employer, any break room owned or controlled by the employer, any time where an employee might not be on the clock, but they're actually during the workday, they're at a place that they have to be at during the workday. They might not be on the clock, but they may be on a work site waiting to start work. If they're on the work site, if they're out at a customer, if they're at a vendor, if they're at a supplier on the job, that would be in the workplace. In fact, the statute goes even further and says, and employer, you can define it even further, defining the workplace. So it's a pretty broad definition. And I would, I'm revising and updating policies for my clients to really broaden as much as we can workplace. Now, you can't get silly with it. You can't say you're in the workplace when you're in Las Vegas on vacation. You can't say in the workplace means that it's at your private home and you're off the clock and not working whatsoever. You can't be you can't undermine the statute. But in the workplace is a term of art. It's actually defined in the statute, and it's a very broad definition. Performing the job, again, performing the job, pretty self-explanatory. On call, that's actually defined in the statute. And on call in the statute means you can be called into work within 24 hours. So employers, you need to be very clear with your employees if this is what you want. If you want to tell them, hey, you can't, just similar to alcohol, no alcohol, no marijuana, or you can discriminate and say, I know alcohol is different, because it is different than marijuana. No marijuana, you can't use it, you can't possess it, and you better not be impaired by it in the workplace, performing the job, or while on call. So then the next question you should have is being impaired defined? I'm going to give you, not exactly, but I'm going to give you some insight that I hope you're going to be hearing for the first time, or if it's not, you're not hearing it for the first time today, it's cementing what you've already heard and give you confidence going forward. Of course, the law does allow, hey, you can discipline and you can terminate an employee for violating your policy, your workplace drug policy. So if you've got, hey, you violate our policy, you're subject to termination, which I think that's what zero tolerance means. You used it in the workplace, you possessed it in the workplace, you're impaired by it in the workplace, broadly defined workplace, you're out of a job. It's highly defendable, and that's what the statutory framework allows. And I don't think zero tolerance is do whatever you want. That's not what it means. Zero tolerance is if someone violates your policy, again, your policy being unique to your operations and industry, there you can do what you want, whatever adverse action you want to take in violation of that policy. Now, before I get to Section 1035, I want to talk a little bit about the Right to Privacy Act. This was the curveball. This was thrown at the 11th hour, and this is where I sort of freaked out. I did not like this. I think they went too far, personally, my personal and professional opinion. The legislators now want to equate marijuana, recreational marijuana, to include, or equate it, I should say, to tobacco and alcohol. For decades, we've had this law in place, right? I mean, for as far as I can remember, we've had this law in Illinois where employers, unless you're an organization devoted to, against tobacco, or an organization against alcohol, employers, you can't refuse to hire or terminate somebody just because they use tobacco products, or just because they use alcohol away from from work, outside their employment. The Illinois legislature amended the Right to Privacy in the Workplace Act to include marijuana. Lawful products means any products that are legal under Illinois law, state law. And so that's the curveball. This is where we have a tension between an employee's ability to smoke or consume or whatever they do in their own private time, bathe in THC oils if they want to, in their own home, in their own residence, off the clock, not performing the job, not on call, and just get high as a kite if they want to, versus maintaining employment, right? And maintaining employment free from the effects of the use of that marijuana, free from being impaired from marijuana at work. Again, remember what I said at the beginning. I mean, because of this amendment to the privacy law, it appears to me, this is just my opinion, but I tend to think that the Illinois legislature has intentionally or not, has created a statutory framework that looks at marijuana, recreational marijuana. I'm just talking about recreational marijuana right now, folks. I'm not talking about medicinal. I'll talk about medicinal when I'm there, and I'll let you know when I'm talking about medicinal. But recreational marijuana, you know, there's a equating it to alcohol seems to be where this legislature went. So there's a tension. Now, having said that, the Right to Privacy in the Workplace Act, I want you to understand that it's not a violation for an employer to offer, impose, or have an effect a health insurance policy, a disability policy, a life insurance policy that makes distinctions between employees and the type of coverage, the price of the coverage, the premium allocation, because they use tobacco, or they abuse alcohol, or they use or abuse marijuana. There's nothing per se illegal or any violation of the law. Of course, you've got to be doing that in a non-discriminatory way. But we've had that for years, and so it's just something for you to think about going forward. We might be getting to the point where, you know, do you use or consume tobacco products? Yes or no, right? When they're filling out the life insurance form or the health insurance application form, I could see us having, do you use and consume recreational marijuana? And if so, okay, what are the ramifications for them? They could be, dare I say, lawfully discriminated against and under some of those benefit plans, similar to what we do with tobacco. Now, the Illinois Right to Privacy in the Workplace Act, something else for you to note as an employer, not overconsumption of alcohol or being impaired by alcohol in the workplace, or the effects of alcohol use or abuse in the workplace, that's not protected under the law. It's never been protected under the law. So if we're going to equate marijuana with alcohol, then the same analysis would be in play here, right? The same approach. You better not be over consuming it to the point where it's affecting or impairing your ability to perform your job. And that is where employers have a lot of discretion, as long as they're exercising their discretion in good faith, to take whatever action they feel they need to take to protect a safe and maintain a safe workplace. Interestingly, you know, despite some of what I've said, you know, one of the questions that was posed to the House sponsor on the House floor, for purposes of legislative intent, are actions of discipline or termination of an employee by an employer for failing a drug test, including a random test, protected from litigation under the law. So a random test, I don't even have, you know, because that conjures up images of, I don't have reasonable suspicion. This person doesn't appear to be impaired. But if they get tested through a random and the random comes back as a positive, the legislative intent seems to suggest that, yeah, you can take adverse action. Now, my opinion, it's just my opinion, the eye is in the beholder of what this question is going for and what the response actually means. There's a lot of presumptions that you got to probably make with asking the question and answering the question. One of those is random. I'm not doing random testing on non-safety sensitive positions. I'm just not doing that. I think employers, I think you'd have potential legal issues by requiring random drug testing for people that are not in safety sensitive positions, or not in positions that would even, that touch on safety. Of course, I'm pretty aggressive with my legal advice and my consultation. If I have a key manager or a key employee that has a key role in the company's or the organization's finances, okay, I can be convinced why we would want to have some sort of random component to that. So assuming we are exercising random testing appropriately, fairly, rationally, and limiting it to certain key functions within the organization, the legislative intent appears to be very favorable to an employer. The problem with the legislative intent here, it looks good, it sounds good, it gives us some confidence, right, as employers, as managers, as legal defense attorneys. You don't get to legislative intent unless the statute is vague and ambiguous and subject to multiple interpretations. So I don't know what a state court judge is going to, how they're going to view Section 10-50, how they're going to view the Illinois Right to Privacy in the Workplace Act. So we might not even get to the legislative intent. And even if we got to the legislative intent, the eye's in the beholder. Section 10-35. So this is a third bucket that I wanted to get to. And this is in the recreational marijuana bill that was signed by Governor Pritzker. Just some things that you should note as employers. Section 10-35. This cannabis law does not allow anyone to engage in conduct or create immunity for anyone engaging in conduct that would include undertaking a task with cannabis, marijuana in their system to the point of being impaired, that would constitute negligence, professional malpractice, or professional misconduct. So nothing in the law allows somebody, in my opinion, to operate heavy machinery or equipment on a construction site, for example, because I think that would be negligent. And Matt Horn is here, folks. I'm doing all the talking. He looks handsome as ever, but he's nodding his head, agreeing with what I just said. Or operating a car or motor vehicle under the influence of cannabis in violation of the Illinois Vehicle Code. What's the Illinois Vehicle Code? I'm going to get to that here in a minute, because that's going to give us a pathway. That's going to guide us, I think, in large part, in how we handle what a positive drug test result is for THC. And then going on, continuing Section 1035, in case it was ever in doubt, you can't be engaged in law enforcement, or you can't be a corrections officer or probation officer if you're using cannabis on duty. In case that was ever in doubt, they felt they needed to codify that. Or being a firefighter, when you're on duty, you can't be using cannabis. And you can't use cannabis if you're driving kids around in a school bus on duty. So thanks to the legislator for that clarity. It was needed, I guess. And nothing in the act, would allow somebody to violate federal law, or would allow somebody at a college or a university to violate the Drug-Free School and Communities Act and whatnot. So I think that's a lot of bubble gum. We talked about workplace. Workplace in the act includes any building, real property, parking area under the control of the employer, an area used by an employee while performing their job, or in a vehicle. And it can continue, again, it can be further defined and expanded pursuant to your written employment policy. And on-call, I've defined on-call, and I talked about that previously. Now, let's talk about impairment, folks. Let's talk about impairment. You should be okay as an employer if you're making your decisions on good faith belief that somebody is actually impaired while in the workplace performing their job or while on call, or you believe in good faith that they've used or they possessed it in the workplace performing the job or on call. Of course, if somebody thinks you should have known but you didn't do anything about it, they can have claims against you if your employee does something that would harm someone else or destroys property of someone else, some third party. So employers, I bring this slide up and bring attention to the fact that I've heard some businesses that are just not going to test marijuana anymore. They're like, we're just not going to test for it. We're not going to test for it on any level. It's, what people do in their own private, life is up to them. I think that is dangerous from a liability standpoint. Marijuana is still illegal under federal law. Marijuana, there's components to the Illinois law and just the law throughout the United States on where recreational marijuana has become legal, where employers are permitted to regulate and forbid the use, the possession, or the impairment of marijuana in the workplace. So if you have reason to believe that somebody may be using marijuana to the point of impairment, or you should have known, it's not whether you knew, is whether you should have known as a reasonable, prudent employer, whatever the heck that means, right? Let the lawyers decide, right? And you don't take action, you don't have policies, you look the other way. I think you're creating a massive, massive lawsuit for yourself down the road. So the problems with the Illinois law is it defines cannabis as a legal product under the Illinois Rights of Privacy in the Workplace law. The law focuses on impairment, seems, and not on just pure use necessarily, right? The law is really focused on impairment. And the law does not provide for employer immunity or limit civil claims against employers if an employer harms themselves and does harm to others in their system. So there's no automatic employer immunity as to what you do or don't do with regulating marijuana in the workplace. That kind of stinks. I wish there was pure employer immunity, but there isn't. So with that, you've got some legal exposures. And I think your legal exposure, of course, if you're not implementing your drug policies, your drug testing policy in a non-discriminatory fashion with groups of people performing the similar jobs, similarly situated employees, right? You've heard that before. If you're exercising and implementing your drug testing policy in a discriminatory way, in an unequal way, not consistent, you're going to create EEO issues under Illinois law. Your legal exposure with this statute is not federal. There's no federal law that I'm concerned with regard to this issue, directly concerned. Where you're going to have legal exposures and potential claims is through Illinois law, Illinois negligence law, Illinois Human Rights Act, the Equal Employment Opportunity Law, protecting employees in Illinois. But the main law in Illinois that I think you're going to have issues with if you don't do this right is the right to privacy in the workplace. And the right to privacy in the workplace, just for time's purposes, allows an employee to pursue claims for you taking adverse action against them because of the lawful use of a lawful product as defined under Illinois law. So tobacco, alcohol, and now recreational marijuana. And the damages are actual damages. So if I lost my job, back pay, what's my back pay? And maybe even front pay, because it's going to take me time to get a new job. Unfortunately, they hire a lawyer. The lawyer can and is entitled to a reimbursement of their reasonable fees and costs. So there's reasons why we want to get this right as we can. If you suspect someone, so this use and impairment, let's talk a little bit about this. And let's talk about medical. Let's talk about medicinal here in a moment, for a moment. If I suspect somebody being impaired or high in the workplace, and even if they are a registered user of medicinal marijuana, they still can't be impaired in the workplace. This is for recreational and this is for medicinal, particularly if they are in a safety-sensitive position. But I don't want people impaired. So if I suspect anyone being impaired, I'm going to fill out a reasonable suspicion checklist. And the reasonable suspicion checklist that you used a year ago or you're currently using, you got to revise that. We've got to be much more creative and much more broad with what we deem to be instances, conduct, behavior, patterns of behavior or conduct that would go towards establishing our good faith suspicion that somebody's just not right at work. And at that point, we're going to follow our drug testing protocol, which would include a test following reasonable suspicion. Reasonable suspicion testing, it's more important now than ever before, not only with recreational, but also with medicinal. And recreational, reasonable suspicion, that's the one testing component that's really universally accepted. I mean, I see that in labor contracts and union labor agreements. I see that in a lot of private employers. Almost every employer that I come across has a reasonable suspicion component. If you don't have a reasonable suspicion component to your drug testing policy, you're going to change that, right? You're going to adopt that going forward. I think that's a no-brainer and something that you really have to gravitate to, especially in light of this law. Now, for recreational marijuana, I think it's good for an employer to provide an employee a reasonable opportunity to contest the basis of why the employer believes the person was impaired at work. So if we go down the path of reasonable suspicion, or we go down the path of we believe in good faith that you were impaired at work, and here are the reasons why, I would say under recreational marijuana, we would want to provide the employee the opportunity to contest that determination. I believe that there might be a requirement in the statute, if you read the statute, that I have May in 2 weeks or a month or next year, I might say does require. I don't know if it's that clean in the statutory framework, but my advice would be give them an opportunity. What does it hurt? Give them an opportunity to contest the basis, because if they don't contest the basis, or even if they contest the basis, you don't have to believe what they provide. And chances are they're not going to contest. And by giving them the opportunity, they don't take advantage of it, it's going to make your position even stronger if challenged. Now, for medicinal marijuana, I think it shall require, you have to give somebody who is using marijuana for medicinal purposes, valid medicinal purposes, and assuming you've gone through that and it's valid, it's legit, you must give them the opportunity, a reasonable opportunity, to contest the fact that you think they are impaired by medicinal marijuana in the workplace. So getting to impairment, I'm building it up. We're close to kind of sort of closing this loop here. Illinois cannabis law provides that an employer may terminate an employee if the employer has a good faith belief that the employee manifests specific articulable symptoms while working that decrease or lessens the employee's performance of the duties or tasks of the employee's job position, including symptoms and that goes through speech, dexterity, agility, demeanor, coordination, irrational or unusual behavior. And that's pretty broad. I mean, that's some broad language there, right? Involvement in an accident, disruption of production or manufacturing processes, carelessness. That's not limited. You're not limited with this language here. It's sort of include, but not limited to. That's how I interpret the statute. So if you do decide to discipline, and you provide the employee a reasonable opportunity to contest your conclusion, I think that again, going to the statutory framework, I see it as, I don't see it as clear as some, but I think giving the employee the opportunity to contest is key. Now we talked about federal law a little bit. It's Schedule 1. It's illegal. I mean, there's Schedule 1 drug. The feds still believe it has no medicinal purpose. It's highly addictive. It's hallucinogenic. It is hallucinogenic, and it can be highly addictive. But to be Schedule 1, it can't have any medicinal purpose. So that's the debate, and that's what's brewing on a national level. We'll see what happens. But I want you to all to understand that if you have employees that are regulated by the United States Department of Transportation, if you have employees that fall under the DOT drug testing regulation, and these employees are employees that are driving the truck, the employees that are mechanics working on the truck, the airline pilot flying the plane, the mechanic working on the plane, the airline. These are unique, narrow occupations that would fall under DOT regulation. If you have employees that fall under the DOT drug testing regulation with regard to medicinal or recreational, you just ignore everything I've said up to this point. That DOT drug testing regulation is going to dictate how you manage and control drugs, including marijuana, under the United States Department of Transportation drug testing regulation. Now, medicinal cannabis, and something I would just caution you on, and this is a complicated issue, but I wanted to bring it up today because it fits. I think that you have to be communicating with your third-party labs. If somebody, like any prescription drug, legal prescription drug, you need to be communicating with the lab, with the collection site, particularly the medical review officer, the physician, the medical doctor, the medical physician that's going to be examining the result and the concentration of any prescription drug that could be triggered or highlighted in a pre-employment drug test. If your pre-employment drug testing is highlighting and testing for legal prescriptions, that's a problem. That's a problem under disability law recognized in Illinois. I think that's a potential headache. So I am cautioning you, if I'm doing pre-employment drug testing, I'm going to be very careful I'm going to be very careful to try and avoid to pick up especially medicinal marijuana. Some of my clients are still, they're taking a more aggressive approach because they feel that they have to for their industry. But in my world, I think that that is a problem, and it's only going to grow. And I think what I'm seeing in other states with courts really being ultra protective of employees that are using legally, lawfully using medicinal marijuana, I just cringe of the thought of pre-employment testing for marijuana, particularly medicinal. So I want to talk with if I've got a current employee who's already started working, they can't have, just like alcohol, they can't have a level of marijuana in their system, or THC in the system, that's impacting their ability to effectively work or creating hazards in the workplace. It's very similar to alcohol, even with medicinal and even with recreational, right? It's a similar analysis when you have an employee who's already working for you. Now, you cannot, just because somebody's working for you and they're a registered user of medicinal marijuana, you can't hold that against them. You just can't hold that against them. But the ill effects or the negative effects of marijuana, medicinal or recreational, similar to alcohol, because alcohol is a legal drug for those 21 and older, you're going to take a very similar approach. Very similar approach. Now, with medicinal cannabis, I like policies established, my drug testing policies. I like policies that will establish that an employee who is under a prescription, including but not limited to medicinal cannabis, has an affirmative obligation to report to the HR manager or to the safety director, somebody who's appropriate to report this, confidentially, privately report any and all ill effects by using that drug in the performance of their job. In other words, you don't have to identify the actual drug that's been prescribed, but I want you to let us know what any restrictions you have in any prescription that you're consuming, any restrictions that would go to the safe performance or the effective performance of your job. So in other words, if you're taking a prescription that may cause drowsiness, if you're taking a prescription that reads, don't operate a heavy machinery, don't operate equipment, don't be, take this, and be bedridden for the next 24 hours after you consume it. If that's what's going on with the prescription, you got to let us know. And then that's going to trigger, if it's medicinal marijuana or any prescription for that matter, it's going to trigger an interactive process, an accommodation analysis under disability law recognized under Illinois law, and perhaps even arguably under the ADA. Your overriding theme in a lot of this, if you can go back and rely on your decision making, and if your policies are designed with safety in mind, that is going to be very, it's going to be very difficult for an employee to challenge your actions when those actions are based on real, true safety, overriding safety concerns. There's a lot of common sense there, right? So we talked about prescriptions. And I want to talk about the fact that Illinois, through the same law, you might have heard about this, creating the opioid alternative program where they're trying to get people on medicinal marijuana to get off opioids. Illinois medical marijuana being expanded. It's here to stay, right? And it's being expanded to include irritable bowel syndrome, chronic pain, migraines. I mean, they threw a lot of other ailments in this. In other words, medicinal marijuana, it's here to stay. In other words, anyone can get a medicinal, can get medicinal marijuana prescribed. And they also expanded who can prescribe it. Because it used to just be the medical doctor, and medical doctors, in fear of their license, because they've got federal mandates that they've got to navigate through and comply with, weren't prescribing it. So what did the Illinois legislators do? Let's expand the reasons for getting the medicinal marijuana, and let's expand who can prescribe it. But remember, you can prohibit registered users from using, possessing, or being impaired while on the job, while at the workplace, while on call, and create zero tolerance that if it's applied in non-discriminatory fashion, can effectively terminate somebody even though they are a registered user. Now, I want to fast forward a little bit and talk about I've talked a lot about some of these slides that I've breezed through here, but I do want to talk about the Illinois Vehicle Code. And I could be oversimplifying this. Maybe I am on some level, but we already had Illinois law that set a presumption. It's the only legal authority that I know of in Illinois where there is a presumption of impairment under the vehicle code for driving a vehicle in the state of Illinois. There's a presumption of impairment if THC level is 5 nanograms or more in blood. Nobody does blood. I mean, if you're doing blood, that's a little odd. Not that it's per se wrong, but I think you're creating more problems for yourself, especially if you're a public employer. Or 10 nanograms or more in any other bodily substance, saliva, urine. So, I think, it's just me, but I think it makes a heck of a lot of sense to create policy that basically says, folks, if you get tested, random, reasonable suspicion, post-accident, post-incident, return to duty, whatever it is, if you test positive and it's confirmed that you have 10 nanograms or more in your saliva, 10 nanograms or more in your urine, I like saliva, remember? We're going to presume you're impaired. And that's similar, and it's a page right out of the Illinois Vehicle Code. So these nanograms and what can be detected through the lab and the type. I think that comes down to the type of lab you're using, the type of testing procedure, and what can actually be, what ultimately can be detected. That's for the science part to try to keep up with the legal part. But you can have this this minimum nanogram level as a component of your policy. And that will help you determine and sort of navigate these waters because you've got a presumption. And if you're giving the person the ability to contest your determination that they're impaired at work, in the workplace, remember that phrase, in the workplace, or while performing their job or while on call, then you have a really good, you're in a really good legal position, especially if they don't take advantage of that. But even if they do try to take advantage, give them a week, give them 2 weeks to try and contest it. And even if they take advantage of that process, it's very likely, but I don't know because it's going to be fact specific, that they're not going to be able to successfully contest. Now, most of the time, these nanogram levels, I mean, I've seen 50, 100, 200. I had a client last month, somebody got tested positive for 1,300 nanograms. 1,300 nanograms. So my understanding is that most of the technology that's out there is going to be, if they do see a positive THC level, it's going to be hitting nanograms of 50, 100, 150. It's going to be well in excess of 10. Also, this is where I would remind everyone to get the nanogram level from your MRO and testing partners. Don't have it's positive or negative. You are going to want to know the nanogram level, particularly of THC going forward. All right, so just a word of caution. The Drug-Free Workplace Act. You can't do whatever you want because you have to comply with the Drug-Free Workplace Act of 1988. Ladies and gentlemen, I don't even know what the Drug-Free Workplace Act of 1988 actually means. It's a lot of phooey, in my opinion, because it doesn't have any teeth behind. There's no drug testing mandate in the Drug-Free Workplace Act of 1988. There's no teeth behind the drug testing component. So some employers feel that, hey, we have to comply with the Drug-Free Workplace Act, so that means we can do whatever we want. Otherwise, we're jeopardizing grants. There's nothing in the Drug-Free Workplace Act that, in the court in Connecticut, I think was right on the money. The Drug-Free Workplace Act does not require drug testing. The Drug-Free Workplace Act does not prohibit federal contractors from employing somebody who uses illegal drugs outside the workplace, much less an employee who uses medical marijuana outside the workplace for medicinal purposes. So the court up in Connecticut said, employer, you can't do whatever the heck you want under your zero tolerance drug testing policy. It's not required. Having zero tolerance for medicinal marijuana is not required by federal law for you to obtain or maintain federal funding. You lose. You shouldn't have terminated somebody for medicinal marijuana just because they tested positive for medicinal marijuana. The employer in that case, their only defense was, well, they tested positive and we didn't want to jeopardize federal funding. And the court said, you're not jeopardizing federal funding. That's a lame excuse. You lose. So as we going forward into this, because I want to spend a little time on some questions, changes to consider in your drug testing policies. And I've got other, I've got some other cases here that I think are some eye openers and some other words of wisdom, but just for purposes of time, I want to go through this list and then I can open up for questions. And I think that would be a great way to conclude this. And so far, the program's been great. I know that we had a few technical difficulties at the beginning of this, but hopefully you've all been able to pay close attention. And I want to get to your questions here momentarily. But before I do, if you're going to prohibit recreational marijuana, and I would say I think you should be prohibiting it similar to alcohol. I would be prohibiting it no less than how we're treating alcohol in the workplace. I think you need to clarify your position on cannabis, recreational cannabis and medical cannabis, and be very clear. Hey, medical cannabis, we recognize medical cannabis can be a prescription. We recognize the potential benefits to medical cannabis. We will not discriminate or take any adverse action just because somebody is a medical cannabis registered user. But here are the rules. Of course, recreational cannabis is, the purpose of that is to get high. We take a much different view of recreational cannabis. I don't care what lanes you pick, ladies and gentlemen, but you need to be really clear to your workforce. You need to clarify your position on use, consumption, storage, while not working, while on breaks, while out in the field, while in my vehicle, whether you're on my dime or not. You better, what is your position? You better not have a level of THC in your system in the workplace performing your job or while on call. Level of THC in your system that would be a presumption of impairment is 10 nanograms or more in your saliva. I want you to be that clear, folks. I want you to define, why not define impairment? We define under the influence for alcohol, right? You define it, 0.02, 0.04, 0.06. I don't know how you define it. The DOT, I think it's 0.04. Define it. Define impairment. And again, using the Illinois Vehicle Code is a really good source. Who wouldn't rely on that? Define the workplace, broadly define the workplace in your policies. Give that really good thought, and that's going to be unique. Traveling employees, employees that are operating vehicles, and employees that have to go to a construction work site or whatnot. Define workplace broadly. Define and distinguish safety-sensitive positions. Be harder, be more aggressive for those that are in safety-sensitive positions. I think the law allows it. What about a 30-day marijuana testing practice? For pre-employment, this pre-employment thing is a little dicey for marijuana, similar to alcohol. Why not have if you're that concerned about it, especially for safety-sensitive positions, 30 days into your employment, you're going to get tested. So we're just letting you know, or 45 days. And we're going to do saliva. Saliva has more of an accuracy, sort of within a week or 2 weeks after last consumption versus urine that's 30 days or more. Why not have like a 30-day or a 45-day or a 60-day or a 90-day? You better have this crap out of your system. You better not have, you're going to get tested. And those nanograms better not be over 10, or cannot be 10 nanograms or more, because if they are, you're going to be subject to termination. It's just food for thought, ladies and gentlemen. I'm adding EEO disclaimers. We don't discriminate in maintaining this policy. We don't discriminate on the basis of race, sexual orientation, gender, et cetera, et cetera. I'm adding language that provides employees when we do believe that they've tested positive, they're in violation of our policy. Give them a reasonable opportunity to contest that decision, your determination. Again, I don't have to believe them, but just give them that opportunity. 99 times out of 100, they're not going to take advantage of it. And because you gave it to them, that's going to be hard. They're going to be hard pressed to come back after you 3 weeks, 3 months, 6 months down the line and then challenge you when they didn't take advantage of your internal complaint or due process mechanism. And then testing triggers need to be updated. Near miss, post-accident, defining it with specificity, random, reasonable suspicion, other triggers that may be warranted. So with that in mind, there's some fluff here with the rest of the material that you can sort of, you can kind of parse through separately, but all the remaining material goes into and really is just a supplement of what I've already discussed here today.
Okay, thank you very much, Jeff. That was very informative. We have had a lot of questions come in during the course of the webinar. First question, will the slides be made available?
I hope, yeah, please.
Okay, very good. First question, is it discrimination if you treat office staff differently than field technicians? So a safety
No,
sensitive position.
no, no,
Okay.
no, 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 no. Office, field, totally different positions. Now, you got to treat all the office people, clerical people the same, generally speaking. You got to treat all the field people the same. That's the, that's the requirement, is to treat similarly situated employees similarly under similar circumstances.
Got it. Okay. And can you recommend a training document for how supervisors can document symptoms?
Yeah, well, we've got that. We can get that over to you.
Okay, so I can send that out in the follow-up email.
Yeah, why not?
And then kind of lumped in with
Happy
that is
to.
another question asking for a sample checklist for reasonable suspicion. I do have a checklist from Samshaw. Is there anything else that you might recommend?
Yeah, okay, so this is you bring up a great point. Get as much information as you can. Don't rely on any one source, right? Review it, inspect it, feel it, touch it, examine it, give it thought before you finalize any sort of checklist or form, because they're not all created equal, and they need to be tailored, unique to your organization. The checklist is a checklist, but without training, the checklist is silly. You've got to have your supervisors and managers that have the authority to fill out a checklist trained. They got to be trained in the.
I totally concur with that.
Yeah.
If a company vehicle is being used off the clock, so presumably this employer allows personal use of a company vehicle, is that considered a workplace?
Yeah, that's a great question, and what does your policy say? I would define that's a unique situation. Again, workplace is going to change employer to employer. If it was my vehicle that I owned and my employee is using it, absolutely, I would say you better not be impaired, you better not be using, you better not be possessing marijuana when you're using my vehicle.
And along those same lines, what about employees that, sorry.
Well, whether you're on the clock or not, I don't care. You're in my vehicle, I get to control.
Very good. What about employees that work from home?
The same thing. You better not be using. I don't care if you work from home. You're working, man. You better not be using. You better not be impaired. You better not, you better not be possessing it while you're working. And now, if they've got a stash of marijuana in their bedroom or in a closet somewhere or in their basement, that's different. And they're not using it. They're not impaired by it. But if somebody's working from home and, I don't know, they fall down the steps and you go get them drug tested and they test positive, I don't care if they happen to be working at home. They could be in violation of your policy.
Okay. Is driving a forklift considered driving?
Yeah, I'd say it's a safety sensitive position. It's driving equipment. I would, definitely.
What about how should employers respond if they suspect employees have a hangover or some side effects, especially due to the strength of the THC?
Yeah. That's the thing with THC. It's a hangover from alcohol is a little different than the side effects of chronic marijuana use. At least studies will show. Again, I'm not a scientist or a medical doctor. That's what I've been told. And that stoner look, right? I think that's where, I think maybe that's where the question it lies, is that stoner state. Somebody's just not right. I think that is real. I think there's a lot of truth to that, personally and professionally. And I think that's all the more reason to have that reasonable suspicion checklist ready to go and have it completed in real time, so that if that's what's going on, you can get them tested. And if they've got if they've got nanograms that are wildly exceeding the legal limits under the vehicle code and violating your policy, you'd be on good grounds to take adverse action. And on that note, some companies aren't going with 10 nanograms. Some companies that I've talked to are going to like 40 or 50. They want to make it so that it's so you've got well beyond the legal limit from a presumption to operate a motor vehicle, that I'm going to make it as safe as I can be from a legal employment standpoint. And they say that, and then I say, well, because you're not testing for 10 nanograms or more, could that be used against you? You weren't, if something bad happens like negligence, you weren't, you didn't take it down to the level that the Illinois Vehicle Code allows. So there's a sort of a catch-22 there.
Okay. After January 1st, 2020, can employers test for marijuana post-accident if there are no symptoms?
Post-accident, there's no symptoms. If in this, Matt could probably say, his 2 cents here, but he's the OSHA guy, and OSHA, right, Matt, allows for drug testing if you think it's a contributing cause, if drugs were or alcohol were a contributing cause, right?
Yeah, so OSHA weighed in on this about a year or so ago with their guidance on drug testing policies, and basically said that you need to have reasonable suspicion to believe that impairment played a role in the accident or the near miss, essentially in order to test them. Because if you have a blanket policy that says you're going to test someone every time they're involved in an accident or a near miss, you're potentially discriminating against them. So you need to have essentially a policy, a reasonable suspicion policy that says that you will only drug test those people following a near miss or accident in the event you have reasonable suspicion to believe that impairment played a role in the near miss or accident. And what example did OSHA give as to incidents or accidents where there was no reasonable suspicion to believe that impairment played a role? They talked about a bee sting. So if you get stung by a bee, that doesn't necessarily mean that you're impaired. Other things would be, no fault accidents. So you have an employee that's walking in a place where they're supposed to be walking and they're struck in the back by a forklift. Should you drug test the person that was struck? Probably not. Should you drug test the forklift operator? Absolutely. So, what OSHA wanted is exactly what Jeff is talking about, which is a reasonable suspicion policy to believe that impairment played a role.
And I would say, and to echo that on post-accident, there's if impairment could have played a role, then you're going to test pursuant to the post-accident and have a post-accident trigger if, again, good faith, you believe that a drug or alcohol could have been a contributing factor to the accident itself. So that's a long-winded way of saying yes, generally speaking.
Would it be prudent for employers to adjust their drug testing protocols with their occupational health providers?
Yeah, absolutely. You got to. You have to. Exactly.
I have a question here asking, to contest, does that simply mean that employees have the right to explain themselves, have the opportunity to explain themselves?
Yeah, give them the opportunity to explain themselves. Hey, man, you got into it. You ran over Marcia with the forklift. You got 50 nanograms in your blood of THC. What do you got to say for yourself? I'm going to be listening like I really don't care what they have to say for themselves at that point, right? But give them that opportunity. You're terminated or establish a practice where, hey, we've decided that your employment is going to be terminated, but before it's effective, we're going to give you, 48 hours, 72 hours to contest our decision.
Okay, very good. What about other drugs like Xanax and Adderall? Can they be regulated in the workplace?
Yes, it's like if it's a lawful prescription, right? I mean, this goes back to what's the science behind your drug testing and your drug panel. Some employers only do 5 panels. They're not going to pick up. I don't, off the top of my head, I'd have to look at my notes, but I don't think that those drugs are getting picked up on a 5 panel. I don't think so. I could be wrong. I don't have the panel in front of me and the information, but so that's why some clients are going to a 10 panel, a larger panel. But if a prescription drug is being used lawfully and is being lawfully prescribed, then that's probably not going to come back as a positive test. It's going to be confirmed by the medical review officer that this is a lawful prescription. But again, it goes back to what are you doing if they're in a safety sensitive position and this prescription that they're on would create a safety problem or could create a safety risk. What is your policy on the employees coming to you with this information preemptively, confidentially, privately, so you can engage in an interactive process? What is your practice and what is your communication with your third-party provider to identify, oh, this person's in a safety-sensitive position, they're on this prescription, this isn't a positive drug test result that I can confirm, but the employer needs to know that this employee is on a heavy-duty prescription that probably jeopardizes their ability to safely perform the job. I need to let the employer know so that they can engage in an interactive process and have a separate conversation with that individual in order to maintain a safe workplace.
Yep, that makes sense. If pre-employment testing is performed, do employers now need to remove marijuana?
I think I answered. I mean, I think it's dicey. I think it's dicey. We're talking about non-DOT. DOT is different, but I got I think I'm not giving advice, but if it was my company, I probably, similar to alcohol, I probably wouldn't test it. And if I'm hiring for safety sensitive, I'm probably going to let people know that, hey, you're being hired in a safety sensitive position. Even though we don't test for marijuana in pre-employment, we're going to test for it in 45 days. So the extent that you have it in your system, if it comes back as a 10 nanograms or more, presumption of impairment under the Illinois Vehicle Code, your employment will be terminated.
Thank you. If an employee is not in a safety-sensitive position, but because of their actions, their drug use, it threatens the good reputation of the company or financial well-being of the company, can you terminate them?
For marijuana use?
Yes.
Just a drug. Okay. I mean, how do you know that they have marijuana use? I don't know.
That I don't know. Maybe they're showing us the
I don't know.
or something.
Yeah. Well, then I would just pick them up on a reasonable suspicion test, right? I know. If the question is, I mean, we think somebody smokes or they admit to some past, use, and we don't like that. What can we do about it? And I think if you're basing it on reputation, I think that's a little weak. I think safety and relying on safety and relying on your underlying policy of not having a certain amount in your system in the workplace, I think that's where I would go.
Okay. Can an employee request a saliva test instead of a urine test?
Oh, yeah, I would. I think if it was my business, I'd be going to saliva testing. All
right, and if you perform a saliva test, how quickly do the levels go down to 10 or less nanograms? If a person used the night before while not working and was tested the next morning, would it already be less than 10 nanograms?
Oh, I don't. Yeah, I mean that depends on the individual and how much they're consuming and are they? Yeah, it's just like alcohol. yeah, I mean, if they're smoking up the night before and you know, smoking like Spicoli, I would think they get hit the next day. That's going to be, I'd imagine it would be pretty excessive.
Okay. Do you know of any commercially available saliva or urine tests that the employer can make available in the workplace?
I don't. That's a good question. I mean, I hear things, but you know, that's for the that's the medical providers. I was up at a pharmaceutical company up north a couple weeks ago, and they're coming out with some pretty cool advances in saliva testing that employers can actually utilize on the spot. But I'm hoping that I think we're closer today than we were yesterday on having this technology in the workplace. But we're not there yet. I would talk to your testing labs, your medical health clinics, your MROs. I would talk to local law enforcement. Local law enforcement has you know, some of the departments that I've spoken to have some great insight in the technology in this world, because the law enforcement that I'm talking to, I mean, they're scared. I mean, they're fearful of safety on the road.
Yeah, I agree with that. Good suggestions. And here's a kind of humorous question. What if an employee claims that they just smelled the secondhand smoke, just inhaled the secondhand smoke?
I didn't smoke, or I didn't inhale.
Right. Right.
I mean, the test is the test. The facts are the facts. I mean, come on. That's silly. I would try not to laugh.
Got it. Now, many of our larger general contractors require post-accident drug testing. What if a subcontractor has to comply with that, or will those go away?
No, I like post-accident. In fact, I am expanding my post-accident testing and my reasonable suspicion testing, and I'm going to be as expansive as I can. You know, near miss, defining near misses, and being more creative in that language to trigger the test, right? And if you're union, because I saw this question, if you're union, drug testing is a mandatory subject of collective bargaining. You have an obligation to bargain in good faith with the union. And in the construction industry, with an association is bargaining most likely on your behalf. What conversations have you had with your collective bargaining association or your construction trade association on this topic? Now is the time, folks, to have these conversations, and the squeaky wheel gets the grease, right? We as employers have to be adamant with these associations and with the unions. This is what we need to do. Let's get a consensus here that protects the workforce and protects the public better than what we have now. Having said that, a lot of the union, most union drug testing policies, in my professional opinion, stink. They're not as good as they need to be.
Okay. Well, that looks like the last question. So again, I wanted to thank you both, Jeff and Matt, for taking time out to share your knowledge and expertise on this very timely and important topic. So thank you, everybody, for attending. We had over 100 attend the webinar today. Obviously, a lot of interest. Have a terrific and safe day.
Thanks, everybody. Thanks, Christina. Take care.
Bye-bye.